In a healthy democracy, the public has a right to know how its money is spent and how its institutions operate. When a journalist, researcher, or concerned citizen embarks on an investigation into the complex world of public contracts, probing the pricing strategies, bids, and quotes submitted by corporations, or examining the ethical conduct of public officials overseeing these deals, they are performing a vital public service. Their work sheds light on potential corruption, antitrust behavior, and wasteful spending, ensuring taxpayer funds are used responsibly and that the market remains competitive and fair. Inevitably, such scrutiny can be deeply embarrassing or threatening to powerful corporations and officials whose lucrative deals thrive in the shadows. A common tactic to silence this unwanted exposure is not to engage on the merits of the findings, but to file a strategic lawsuit against public participation, or SLAPP. These lawsuits, often based on defamation or business interference claims, are not designed to win in court. Their purpose is to inflict a different kind of victory. They bury the investigator under a mountain of legal fees, paralyzing fear, and protracted court battles, effectively chilling the speech and stopping the investigation in its tracks. This is where anti-Slapp legislation becomes a critical shield for free speech and public accountability. These laws recognize that certain speech, especially on matters of profound public interest like government spending and corporate ethics, is so essential that it deserves protection from legal bullying. When a corporation files a meritless lawsuit to silence a creator's reporting on torrid business dealings, the investigator can file an anti-Slapp motion. This motion asks the court to quickly dismiss the lawsuit because it targets protected speech on a matter of public concern. A robust anti-Slapp law then turns the tables on the powerful. If the court agrees that the investigation was protected speech and the corporation's lawsuit lacks merit, the corporation, not the investigator, can be held responsible for the defendant's attorney fees and costs. This powerful legal mechanism serves as a deterrent, sending a clear message to would-be censors. You cannot use the courts as a weapon to silence legitimate public scrutiny. In essence, anti-Slapp laws ensure that the courtroom door cannot be slammed shut on truth-tellers. They affirm that the public's right to know about potential corruption and anti-competitive behavior in its name cannot be auctioned off to the highest bidder or silenced by the most intimidating legal threat. They are a foundational defense, ensuring that transparency and accountability, not fear and intimidation, govern the relationship between the public, its government, and the powerful corporations that seek its business.